Hello, Michigan Realtors, and welcome to a special Letter of the Law and From the Mailbag mashup. By most accounts, August 17th came and went without incident, and the sky remains firmly above us. That said, we continue to have great discussions with Realtors about the expectations under the settlement. We have also noticed a renewed commitment to getting back to basics. In under 2 weeks, we'll be attending the convention at Soaring Eagle Casino in Mount Pleasant, debuting the annual legal update, affectionately known as Within the Law. Registration is still open, so we hope to see you all in attendance. Now, for Within the Law, Becky and I will be truly going back to basics to revisit various agency concepts, disclosure requirements, considerations when working with a buyer as a customer, advertising, and much, much more as we navigate the real estate marketplace post-August 17th. In anticipation of a great convention, we wanted to touch on some of the recurring legal questions that we have been fielding. So without further preamble, Becky Burke, I have some questions for you. First off, can my brokerage firm enter into a contract with another firm where we agree upon a cooperating split for all cooperative transactions involving our two companies?
That's a good question, and the answer is no. Under the NAR settlement, it is the seller, not the listing broker, who decides whether or not there will be a cooperating split offered, and then if so, the amount of the split. A listing firm should not enter into an agreement that would purport to commit all of their future sellers. Moreover, regardless of any agreed upon split between the listing firm and the cooperating firm can receive no more than the amount agreed to by the particular buyer in their contract with the cooperating firm. So in short, going forward, commissions paid to cooperating firms must be dealt with on a per transaction basis.
Okay, another question for you. If the listing broker is offering compensation on the property, should my buyer still include a request for compensation from the seller in the purchase agreement?
That's another good question, and the answer there is no. In a scenario where the listing brokerage is offering compensation, the brokerages might want to execute a compensation agreement between brokers. If the compensation is coming from the listing broker, it should not be part of the purchase agreement because the listing broker is not a party to the purchase agreement. In a scenario where a listing brokerage is not offering compensation to a buyer broker, or if it's unknown as to whether or not the listing office is offering compensation, then the buyer can use the purchase agreement to ask the seller to contribute something toward the buyer's obligation to compensate their broker.
Got it. All right. Well, I'm gonna ask you for a couple questions now.
I would love to give you a couple questions.
Let's do it.
All right. Given the new written agreement requirement, do we still need an agency disclosure form?
Yes. The agency disclosure form is required by Michigan law and should be provided to a buyer or seller prior to the disclosure of confidential information. Now, the NAR settlement did not change this requirement for Michigan real estate licensees at all.
Got it. Still need an agency disclosure form. I have another question for you.
Fire away.
If the seller signs a buyer-broker compensation addendum, or if they, agree in some other way to, pay for commission in the purchase agreement, do we still need the compensation agreement between broker form?
That's a good question, and it's one that's coming up a lot. The answer is no. The compensation agreement between brokers is only to be used when the listing brokerage is offering cooperating compensation. Now, this is an agreement between two brokerages, not the buyer and seller. If the seller has agreed via the purchase agreement to compensate the buyer's broker, either directly or through a concession, then the listing brokerage should not also be asked to pay the buyer's broker. All right, back to you. I've got some questions as well. So, Becky, does the broker need to sign the compensation agreement between brokers, or can a salesperson sign it?
That's another good question. So a salesperson can sign a compensation agreement between brokers on behalf of their broker if the broker has authorized them to do so. The same is true with listing contracts and buyer broker contracts. Brokers really should have written policies in place that lay out the circumstances, though, in which an agent can sign contracts on behalf of the company. For example, a broker may have approved forms that a salesperson can sign, but require broker approval for, any other form or any changes to an approved form.
Right, and so that dovetails nicely with this next question. And so I'm a broker with strict policies as to when my salesperson can sign a compensation agreement between brokers on behalf of the firm. Now, one of my salespersons violates that policy, signs a contract they never should have signed. Is my firm bound by that unauthorized contract?
Good question. Yes, the firm would be bound by that contract unless the other broker knew that your agent did not have the authority to sign the contract. But, as a general rule, parties are permitted to assume that the person signing the contract on behalf of the company had the authority to do so. So the broker's remedy, if anything, would be against the salesperson who signed the contract.
All right, I'm back on the hot seat now. What do you got?
I do have some questions for you. So, what is the difference between the buyer broker compensation addendum and the seller concession addendum?
Great question. We've been getting this one a lot. So prior to the settlement agreement, buyers often asked sellers for seller concessions, meaning that the buyer would request that the seller contribute an agreed upon amount toward the buyer's overall settlement costs, such as closing costs, prepaid items, and the like. The seller concession addendum adds the buyer's agent commission to the list of expenses that the seller concession amount can cover. Now, if the buyer is not asking for the seller to contribute to settlement costs, but only the buyer broker commission, then you can use the buyer broker compensation addendum.
Got it. Makes sense. And I have one more question for you.
Let's do it.
I am a listing broker, and I have agreed to pay the cooperating broker, say, $5,000. The buyer's agent has presented the seller with an offer asking the seller for concessions, say in the amount of $7,500. Is the commission amount going to be included in that $7,500?
That's a really good question and a very important determination to be made by the seller and the listing broker. The answer is no. And if your seller accepts this offer, they will be required to contribute $7,500 toward closing costs in addition to the compensation that you have already agreed to pay the buyer's agent. So we have to be very careful when reviewing offers and the appropriate forms to actually achieve the goal of that buyer and obviously not leave the seller in the position to be paying double. So, all right, that is 8 questions down, and that's a great place to pause until next time. Please keep those questions coming. With your help and input about what you're seeing out there in the field, we'll all be in much better position for it. Thank you for watching, and we really hope to see you in Mount Pleasant.